Good morning and welcome to our December webinar. As you can see, I am not sitting by myself. I have somebody with me, which is lovely. Chris Harber, our Head of Immigration. So welcome, Chris, and thank you so much for joining us. And also, no apologies. It is Christmas jumper day in the office today, so hence the attire. Thank you very much to everyone. Again, fantastic numbers of people engaging with our webinar programme. So that's really pleasing. And thank you very much for joining us today. I do hope you are all well. Just a bit of housekeeping, if I may, and we are live. I will be sending out a recording of the webinar after the event. So please do make sure that you are signed up to receive those. For those of you who don't know me, my name is Emma O'Connor. I'm a legal director in the employment team here at Boyce Turner and also head up our HR training academy, which trains managers, employee populations and HR teams. Recent examples have been Manager Masterclass, Manager Essentials, keeping HR teams updated with what is going on in the world of employment law. So lots of things going on. Within the team, we assist clients both in the UK, across Europe and globally as well on HR support, litigation support. And Chris, in your team, what sorts of things are you advising clients on? Because I know you're very, very busy.
Yeah, we are in a quite a busy phase now, as I'm sure all of you have probably figured out for the last week or so. So we within the immigration team do everything that falls under the UK immigration banner. So obviously I already represent a number of you. We handle sponsor license applications, visa applications under every category within the immigration system. And then on top of that as well, lots of compliance training, lots of things like right to work training, which we were just talking about. Lots of workforce planning exercises as well. So thinking about how to make use of the immigration system, depending on what your budget looks like over the next few years. If you're a global company and you operate in several countries, what that global mobility strategy looks like as well in terms of where you place your staff.
No, absolutely. And I think with regards to the training, certainly in-person, pre-recorded e-learning modules, as well as webinars as well. So do get in touch if the right to work training is something that you're key to sort of roll out, not just for your HR teams, but also for your managers as well. So without further ado, we will make a start. So I mean, Chris, what hasn't been happening in the world of immigration, I think is more of a question.
Yeah, it's been a really ridiculous weeks. Everything was ticking along quite nicely. We had a fairly sort of clear, settled picture of what 2024 was going to look like from an immigration perspective, and I had all of my notes prepared for this webinar quite nicely until last Monday when our dear Home Secretary blew all that out of the water with his 5-point plan. So what I'm going to focus on initially today is going to very much be precisely that, the 5-point plan. There are a couple of other areas that I'm going to look at as well. So the key areas that are going to be coming up in 2024 are listed here. The big issues that we're going to be coming across are really around a cost-based issue. So the primary issue that I've put up at the top there, which is going to be the immediate concern over the next couple of weeks, is the increase to the immigration health surcharge, which is due to come in on the 16th of January.
And what is that health surcharge, just to explain to those that may not know?
Yeah, so when you apply for a visa application, there are a number of different fees which are associated with the process. One of those is what's called the immigration health surcharge. Now, I've got my own personal views. I'm not going to go into what the health surcharge and its utility is at the moment. Basically, what it is that it's the government's sort of charge that they levy on visa applicants to use the health system in the UK. Unfortunately, it's not discretionary. It's a mandatory fee. Even if you have a private healthcare provision, you still have to pay this fee because it covers free at the point of use services such as GPs and A&E services. So the health surcharge was introduced in 2014, initially at £200 a year, the pricely sum of, and it's increased ever since. And certainly the Conservative Party have always been committed in their various manifestos over the years to keep increasing that fee accordingly as we go through. Now, the latest increase to that is going up in January 2021. It's going up from £624 a year to £1,035 a year. So quite a substantial increase, unfortunately, from where we are at the moment. Now, what that means, practically speaking, is that for a lot of applicants who are going through the process at the moment, we need to be looking at what their costs are, whether we can get their applications expedited and get them in nice and early. So it's something that we are looking at quite actively as a team, and we're trying to prioritise the applications as we go through. I'm just loading up to see if there's a quick question. Thanks, Nicola, for the question. What I'm going to do as we go through is we'll take sort of periodical pauses as we get to each step, to make sure that we're addressing any questions as we go through. So if you have any questions at all, feel free to put them in the Q&A, and then we'll address them as we go through. So question from Nicola, just to read out, is if you have sponsored any individual who are midway through a 5-year visa sponsorship, will the health surcharge increase for them or only for new applicants? Really, really good question. So it's only going to be for new applications. So it's going to be for applications both in country and out of country. But if you already have a live visa that's going to continue through for the next few years, then it will continue as it is. You're not going to be expected to pay an increase on that from January. So good question.
And also with the health surcharge, is that for any dependents as well that come in?
Yeah, so the 624 is the adult cost. So that's for the main applicant who you're sponsoring and their spouse when they move over. There is a discount if you have any dependent children who are under 18. So at the moment that is £470 a year, and that's going up to, I think it's £776 a year in January. So it's an increase for all, unfortunately. So yeah, so that's the health surcharge. That's kind of is what it is really. So we're just going to leave it there and focus on the 5-point plan really. So two other bits on this slide, which I'll just very briefly touch on, but then we're going to spend the majority of our time focusing on the Home Secretary's announcement last week. So there is a change to the visitor rules coming up at the end of January as well. And what that's going to allow is it's going to mean there's a very slight relaxation for certain types of business travellers coming to the UK. So if you're a multinational workforce, if you're based in several different countries and you have a lot of travel between your offices, then what the Home Office are introducing is a new concession that allows remote working as long as it is not the primary reason for why you're travelling to the UK. And that's the really important point there. So as a good example, if you have an internal project that you're working on and you have someone in, say, your Paris office who is a bit of an expert on that area, on that project, and could do with being in the UK, they can come over to the UK, advise on the project as they go through. Whilst they're here, they can continue doing their normal day job effectively. So answering emails, taking calls, doing their normal sort of day-to-day workload. It's kind of a recognition of what is already existing practice. The Home Office already have a slight sort of tacit acceptance that people are happy to look at emails and things and do sort of incidental stuff whilst you're in the UK. This is really, it's just a formalisation of what's already actually happening in practice. But nevertheless, it's good to have that recognised by the Home Office. And then just the last point on this slide before I go on to the 5-point plan is that 2024 is the end of BRP cards as we know them. So they are being phased out. And as anyone will see who has done a visa for anyone in your workforce, the BRP card is valid until the end of December 2024. From 1st of January 2025 going forward, all right to work checks will need to be done online as they are at the moment, but you won't have that kind of sort of worry about whether you need to keep a copy of the BRP card or not. And everyone's immigration status in the UK will be entirely digital. So there will be no physical documentation from 1st of January 25. So that's going to be a bit of a sort of a knowledge point, certainly for applicants as we move through the year, and just making sure that's reaffirmed and that everyone knows what the rules are in terms of how to conduct a right to work check when we get through to 1st January 25.
So again, that training and knowledge, particularly for your HR teams and your managers, is going to be absolutely crucial. If that's the case. Just on that BRP, what does the BRP stand for, and what would happen if somebody currently has one of those cards, and then we're obviously moving to the digital system? Do you wait for it to obviously expire, as you said, or should people be moving onto this digital system now?
Yeah, so the transition has already happened, and it happens automatically, thankfully. So from an applicant's perspective, they don't need to do anything. Their online accounts are already set up. They use, depending on how they applied, they either use the card number that's printed on the front of the cards to access it, or they'll use their normal login details, their email address and password. BRP is biometric residence permit, so it's the little pink and blue card. Looks a little bit like one of the ones which we had on the one of the earlier slides. If I go back ever so quickly, if I can move the screens backwards.
And so
there we are. That's it. So that's what it looks like just there.
Fine. So for our clients, for our employer clients, there is nothing that they would need to do with that.
No, nothing at all. No. Good. Okay, so primary focus of what I'm going to cover today is the Home Office's 5-point plan for reducing net migration. Now, again, I won't go into the politics of the decision and say that's a separate conversation for another time. What I'm going to focus on today is the actual implications to you as employers, for your workforce, maybe potentially for yourself as well. And then we're going to have a look at what practical measures we can do over the next few months to try and mitigate some of the changes that are going to come into place. So obviously the big headline figure that has been announced is that the minimum salary for the skilled worker route is going up from £26,200 a year to £38,700 from springtime. Now, when the Home Secretary says spring, he probably means 5th of April, because the Home Office tend to align these sorts of changes with the tax year. So, what does that mean practically? Well, first and foremost, we know that is going to mean that for any new applications where the candidate is outside of the country at the moment, if the application is submitted after the change, their salary has to meet the new threshold. So 38,700 or above. Now,
there are no modifications from that. That is a flat.
There is this is where it gets really complicated. Okay. There is potentially, certainly for new entrants, which I'll explain in a second, there is a potential caveat that we don't know what the rules are on it yet. So if you're say, for example, at the moment, if you are looking to sponsor someone whose salary would be let's say £30,000 a year at the moment. At the moment, that's absolutely fine. It comfortably exceeds the minimum salary thresholds, and we can proceed with that. From the changes, that's obviously going to stop, and you'd have to then make a decision at that point as to whether you want to continue with the application and pay them more, or if you want to stop with the application entirely. Now, obviously, for a lot of instances and for an awful lot of our clients, certainly the ones that work in hospitality, we are seeing that this is going to be transformationary in the sense that it's going to completely lock out a whole sector of the workforce, which is going to have its challenges. The next change is the changes to the way that the care worker visa works. So from springtime, any care workers that apply for a visa to come to the UK will not be able to bring their dependent family members with them. This is a little bit of a second degree effect type policy where the Home Office are hoping to make a change over here with the intention that it has a change over there type thing. But nevertheless, the intention is that it's designed to reduce the number of care workers who are moving to the UK. There's going to be I said scrapping the shortage occupationist. That's not the language that the Home Secretary used, but it's basically what it is, really. If we're being honest, they are and the shortage occupationist doesn't really serve a huge purpose anymore. The only real material change that you have with a role being on the shortage list is that there is a 20% discount on the salary, on the going rates for the salary. And the merits of that you can argue either way. So there isn't really a huge purpose for the shortage occupationist anymore. So this is more just a sort of a clarifying point, really, and it's an easy sell for the Home Office, for the Home Secretary, from a political perspective.
So there are effectively no jobs now that are on any sort of shortage occupation list.
No, they said that they're going to introduce, I can't remember the terminology he used, maybe I think it was a salary exempt list. I can't remember what so where there is a real urgent critical need, there is going to be some element of it, but yeah, in broad principle, it's gone really. The fourth point here is probably the most controversial and is going to cause the most disruption and upheaval to individuals. Maybe yourselves, almost certainly some of your employees will be affected by this. So if you are either a British citizen or you are settled in the UK, so you have either settled status under the EU settlement scheme or you have permanent residency, and you are in a relationship with someone who is not either a British or Irish passport holder, then for your partner to be able to live in the UK with you, you need to meet the salary requirements. And at the moment, that is 18,600. So when you apply for the application, obviously, first and foremost, you need to evidence your relationship. So if you're married or in a civil partnership, or if you're unmarried and you've lived together for at least 2 years. The salary can be met by either the settled person or the applicant, if the applicant has got a guaranteed job offer. So there are different ways of meeting the salary thresholds. However, that 18,600 threshold is going up to 38,700. Now, feels like that's a very arbitrary figure that the Home Office plugs, because they've aligned it with the skilled worker threshold. The basis that they've used for this is that they deem that it's the median salary. The trouble with that justification is that the 18,600 figure was never based on median salaries. It was based on eligibility criteria for benefit payments and universal credit payments. So it's never actually been anything to do with median salaries and saying that because you earn the average amount of salary in the UK, you can bring a partner over. Effectively, what the Home Office is saying now is that if you are in the bottom 50% of earners in the UK, then, which is obviously by definition half the working population, then you are no longer going to be able to bring your partner with you to the UK if they're not British.
And I did see a wonderful tweet that said after the announcement that something like 60% of the British population could no longer actually apply to work or apply to HB, so we should all leave. So I thought that was quite a humorous take. But again, you know, a lot of people who are bringing their spouses or partners with them, you know, they will be traveling with, you know, they will be caring for children. So you know, it is a huge jump there. And you know, obviously people trying to find work that will give them that salary. And particularly if you are looking for part-time roles, you know, if you've got other responsibilities. So no, I can see that as a huge burden on individuals. And again, you know, the care workers as well, you know, making that an attractive role for people. You know, and not being able to bring your dependents. Would that apply to children as well? Or is that partners and husbands?
It's the salary requirement, but by default, the child wouldn't be able to apply without the parents anyway. So we stray into very sort of unusual circumstances, but say both parents are British or settled, then there would still be a salary requirement. And if the kids weren't, but that's becoming a very sort of niche situation.
And of course, a care worker has to have a role that pays 38,000.
So care workers are exempt.
They are.
So this is one of the areas which we'll move into.
That's good.
So there is an exemption for care workers on the salary threshold. But yeah, it will be highly disruptive to a lot of families around the UK. Fully expect a raft of legal challenges to this under Article 8 of the European Convention on Human Rights.
Right to family life, isn't it?
Yeah, exactly. Yeah. So we're expecting a large percentage of potential applicants under this appealing under various different routes. So the ship has by no means sailed on the family routes. This will drag on for a long time.
Yeah,
really,
I can imagine.
And go through quite a lengthy and ultimately a very costly process through the courts. And it will probably be one of those decisions, as with the Rwanda scheme, where it ends up in the Supreme Court for an ultimate decision. So yeah, we have a long road ahead of us with that regard. And then the final one on here, just before I go back to the skilled worker category for some of those exemptions areas, is the Home Office have asked the Migration Advisory Committee, who are their advisory body, to conduct a review of the graduate routes. So if you've been a student in the UK and studied here, and obviously you're from overseas, once you've completed your course, you have an option to apply for a 2-year graduate visa, and that gives you 2 years for, extra to work in any role, in any capacity within the UK. The intention is that it's designed to give people 2 years to find their feet if they want to live in the UK, 2 years to apply for a skilled job. We've all been there, left university, wondered what we're going to do. So the idea is that it's designed to give people a couple of years to settle down, find their feet, get a skilled job, and then transition into the skilled worker route eventually.
And isn't there a dependent issue with the graduate route as well that is being looked at?
Yeah. So something that was re-announced last Monday, but has already been announced, is that if you're a student, then again you can no longer bring dependent family members with you. You can only bring dependents with you if you're doing a postgraduate research level, so effectively a PhD, either an MPhil or a PhD. Realistically, is what you need to be doing. So yeah, so that's pending, and then the Home Office will take the max recommendations on that going forward. I'm not expecting any significant changes to the graduate route. It's proven to be a very successful route in allowing
universities are very keen for it to continue.
Yeah,
because of the funding issues
yeah,
as well.
exactly. So we'll see what happens with that one.
So this 5-point plan, that's not something that is now open to consultation. That is the plan.
Correct. Now, with immigration law and the rules, you have the Immigration Act of 1971, which underpins the entire immigration infrastructure, effectively, legislative infrastructure in the UK. And then that devolves power to the immigration rules, which is what's known as a statutory instrument. Now, the Home Secretary has discretion to amend the immigration rules as they see fit, effectively. So what happens when these sorts of things are changed is that the Home Office publish what they call a statement of changes, and that is the Home Office laying down a statement to Parliament saying we are going to change the following things. That's a detailed document, and that hasn't been published yet. So all of the detail of all of this is yet to come out.
So just at the top level, this is what this is the intention, and then like everything, it's always the devil, isn't it? Is in the detail of it. Exactly.
And when it comes to the skilled worker salary threshold, the devil really is going to be in the detail. We don't yet know how it's going to be applied to in-country applications. So whether that is for example, a graduate switching into the skilled worker routes, or someone that you're already sponsoring who you're looking to extend. We've had zero communication on those scenarios at the moment. If you had to pull me one way or another, my hunch would be to say that the salary threshold, the new salary threshold, would not apply to anyone who you're currently sponsoring. Again, that's my hunch. That's not been confirmed anywhere at the moment, but it would feel disproportionately damaging to businesses if you said that, well, you've got this person who you're sponsoring, and their salary is 30,000 a year, and their visa expires in a year's time. So when that visa expires, you suddenly need to go and find another 8,700 to keep them
on top of pension, national
Yeah.
insurance, etc.
Exactly.
You know, so that, I mean, you know, you're probably looking at probably nearer to 50.
Yeah.
If you add in all the
other contributions. Yeah.
Exactly.
So it would feel disproportionately unfair to do that. The Home Office don't have a good track record of making fair decisions.
No,
which is always to be kept in the back of our minds when these sorts of things are going through. But we are very much watching like a hawk when the statement of changes come out. And I'll come on to potential remedies in a second, which we'll look at. But there are some options there for us around potential extensions. Just going back to one thing that Emma said earlier around sort of caveats and exclusions and things. So at the moment, we have something called the new entrant rate. Now, the new entrant rate is eligible where a candidate is either under 26 when they submit their application, or they are switching either from the student visa route or the graduate visa route directly into skilled worker. So it's designed specifically for what it's called new entrants.
Yeah.
People who are at the beginnings of their careers, where it would be unfair to expect their salary level to be the same as someone who has been 10, 15, 20 years into a career. So at the moment, under the 26,200 salary threshold, the new entrant rate is 20,960. So a fair discount. Fair discount. So that's where the two interact. Again, as with the other areas of the detail, we don't know how that's going to change with the rules. My assumption is that it will move proportionately with it. So the brackets will just move.
Oh, so they will put that minimum, you know, the sort of the figure up. Wow.
Yeah, I'm anticipating that it will go up, in which if you apply the same delta, the same difference at the moment, then it would be about 27,000.
Okay.
The new entry. So it's still an increase.
Absolutely.
And it's going to because obviously this is mainly talking about graduate type jobs and sort of
yeah, but if you are thinking about graduate type jobs like teaching, you know, those other sort of jobs that have, you know, a salary of that would be kind of around that figure, it does make it more attainable for graduates to be able to do their degrees and then find work, you know, if that is their wish. So
it certainly will impact a few areas. If they keep the new entry rate, then it will still be of benefit. And then really importantly as well with care workers, so the health and care visa, so the category that doctors, nurses, physiotherapists, massage therapists, care workers all use, that is completely exempt from this. So the existing salary bandings for the health and care visa are staying exactly the same. So there won't be any impact on your local hospital's ability to recruit a nurse, for example.
Just the ability to bring dependents over. So you know, we do act for a number of clients within the care sector. So hopefully that will give you some comfort there. And obviously if we've got people on the call today that want to speak to us about that particular sector and area, then please do, you know, get in touch with us.
We'll just do a quick cover through some of the questions that have come through. So we'll go chronologically. So first of all, from Lucy Black, thank you, Lucy. So just reading out for the benefits of everyone. So the question is, in relation to right to work checks being entirely digital, does this apply to people with UK passports too? At the moment, we do the check. We do check the physical documents and save photos of passports online. Will that change? Fantastic question. Really, really good question, because that's very pertinent. So the digital checks that are coming in that are already in place and are going to be more effective from Jan 25 are only for visa holders. However, separate to that, the Home Office have also introduced a new separate third-party ID verification service, where they have effectively outsourced all of this to third-party providers. So what you can do, and many of you will already do this, where you might use a third party company to verify things like references and the genuineness of documents and CVs and things like that. So they'll do like a search check effectively for you. Lots of those companies are moving on to this new system. So what you can do is, at the same time as asking them to do a background check on someone, you can ask them to do the right to work check for you. So you're effectively outsourcing the right to work requirement to the third party provider. Obviously, there will be a fee structure to that the provider will put in place with you. But there is going to be an option so that eventually, once those providers are, and that market is mature enough, you will then have an option where you don't have to be doing any physical documentation checks whatsoever. Which is good. It's good. It takes a lot of risk away.
It does, and I think with the digital check, I think it's going to be great for those businesses that do have a huge throughput of individuals.
Massively.
Always check
Massively.
with my employment lawyer's hat on. Obviously, always just make sure you've got your protections in there, particularly with regards to sort of data protection, because obviously you're sharing personal data on that one. But yeah, so there is that option to do that. No, really good. Thank you for that one.
And thank you, Lucy, for the question. That was a great question. Next question, Lorraine Higgins. Thank you, Lorraine. So the question is, if someone is already on a sponsorship visa and not due for renewal come the date of implementation, would we need to increase the employee's salary to meet the visa requirements now set? Again, fantastic question.
Yeah, so if you advertise a job in February and the person is starting on the 5th of April, say, if that's our sort of, in our sort of boy Santa crystal ball, is it the point that they join, or I guess the point that you've advertised?
Yeah, and the
already on license. Yeah.
The key thing with the way that the visa system works, and the way that it's always worked, is that the rules, the goalposts don't move. So when you're granted a visa, the conditions that are in place on the day that your visa is issued are the conditions that apply to you for the whole length of that visa. That's a long-standing principle of the way that the visa system works. There's got to be some level of certainty at the very least.
For both parties, isn't it?
Yeah. So Lorraine, you're not going to have any situations where you are sponsoring someone through, and let's say, for example, their visa expires in 2 years' time. You're not going to have to suddenly increase their salaries come April to meet the new thresholds. That won't be the case. So yeah, that's at least a little bit of assurance for sponsors.
But again, we don't know if it's going to be, if you advertised a job in February at 26,200, but the person doesn't start for whatever reason until mid-April.
It would very much be on the day that we submit the visa application. Fine. Is when the Home Office will make that determination. So as long as the actual application is submitted online and the payments are made, you are then locking in the rules that are in place on that given day. Yeah.
So I guess that means for things like workforce planning, if you are looking at recruiting, it might be better to do it sort of sooner rather than later. Charles, we'll park your question, because I think that's one to sort of cover off at the end.
And that leads quite nicely on from that. So Charles, we will cover your question, but that leads quite nicely on at the end in terms of what we can do over the next few months, really. So thank you for that. So that brings us fairly well up to date in terms of what 2024 looks like from an immigration perspective. Obviously, the elephant in the room is the general election for when that comes around as well. So that could be any moment. There's a theory that the 5-point plan that they've introduced suggests that the government are looking at a springtime election. Because part of the issue with with these changes, and as Charles has alluded to in his question, it's probably going to result in a bit of a mad rush to get applications in before the thresholds go up. So when next year's net migration figures are published, I'm actually expecting there to be an increase in net migration over the next year, because the way that the data is analysed is that it takes the year of June to June. So we are in next year's net migration figures already. So any applications that are submitted between now and when the rates go up in April count towards net migration. So what the government will probably want to avoid is having an election shortly after that, where the ONS publish their data, and because of the rush, hey, suddenly net migration is now 800,000 a year. That will look from a
political point of view,
from a political perspective,
yeah,
suicide. It will look awful from a political perspective. So I wouldn't be surprised if this 5-point plan is an indication that the government are looking to a spring election, where they can do this before the figures come up, because the importance that the government have placed on this in terms of the ministerial time that it's taken up over the last few weeks shows that they see this as being a big battleground when it comes to the election. So if the election is after the next migration figures are published, if they haven't gone down, then they are in deep trouble, really deep trouble. So I wouldn't be surprised if they're going to do this at the election before the next ONS data is published in August time.
Well, reasons to be cheerful.
Yeah.
Really.
Yeah. So we have the election on the horizon. The indications so far are that Labour are probably not going to reverse these decisions. They are sort of not quite in lockstep in terms of the principle of them, but they agree that net migration is too high and that things need to be done. So we will need to wait and see what the detail of Labour's manifesto looks like around this area. But
particularly around kind of open borders and things like that.
Yeah, I'm not expecting any significant changes. But yeah, okay. And then do you want to should we do Charles' question before we do your employment stuff? Yeah.
I think really, what we've obviously talked about, and I think, Charles's point is there likely to be a rush of employers trying to beat the new limits?
Yeah.
Yes. and it would be wise to, and I think, particularly around, the salary increase, if you are thinking about recruiting, making those plans earlier and making sure you allow yourself enough time to be able to make applications, because, these things undoubtedly, with more people making applications, Chris, I imagine there is going to be more of a backlog with the Home Office. It's, and
it's a little bit of a worry with immigration practitioners. So I was last night I was on a working group with the Immigration Law Practitioners Association. So it's other immigration lawyers around the country, and one of the concerns that is coming up is that the infrastructure of the Home Office won't be able to deal with the influx applications. And it may, for those of you who have licenses and know how the system works, the process of applying for an increase to your certificate of sponsorship allocation, which is it's a really routine admin piece of having a license, but it's genesis really for an application. If you haven't got an allocation, you can't do a visa application. Okay. And the process of requesting an increase takes the Home Office about 3 to 4 months to process the request, unless you purchased a priority service for an extra 200 quid, and that's limited availability as well. So there is a suggestion, and I think a very credible suggestion, that the number of license holders who are going to be asking for an increase to their allocations to facilitate applications over the next few months is going to cripple the Home Office's ability. So we will have to watch that one exceptionally closely. There are fallbacks, there are ways of submitting visa applications in lieu of having a certificate sponsorship. It's not something the Home Office like people like me doing, because it causes them untold grief, but it is within legislation, it is a tool that's available to us. So in the worst case scenario, if we do get to a position where, for example, you have a worker whose visa is going to be expiring and there is no way that you would ever be able to increase their salary to meet the new thresholds, but you want to keep them on and we need to get the application submitted quickly, do get in touch, because there are ways of submitting applications in lieu of sponsorship to lock in the rules that are on a particular day when we submit the application.
So sort of, I suppose it's going back to Lorraine's point again. So if somebody's visa is coming to an end, say on the 1st of June, and we want to retain them, the point was that we wouldn't have to increase the salary for the job.
Yeah.
It would be what they were. Okay, that's fine.
Yeah.
I was just thinking, is there a way to make, is there a, you can apply to extend 3 months before, 2 months before?
You certainly can, yeah. So if the worst case scenario occurs and the Home Office apply the new threshold to every type of application,
Yes.
including extensions, then even if you've got someone whose visa expires in say 2 or 3 years' time, we can apply now,
Yeah.
take them up to all the way up to their eligibility to apply for permanent residency, lock in the new rates now. Obviously, there's an increase. You're effectively front loading the cost of the extension
You are.
by doing that. So you're bringing a lot of costs forward. So
Yes.
there might be budgetary issues from that route, but you would be locking in the salary rates as they are now, rather than having a hurdle in a couple of years'
Absolutely,
time.
and what uncertainty there may or
Yeah.
may not be. So yes, there's some
Yeah.
considerations there.
Yeah.
So taking obviously everything that you've discussed, and again, fantastic overview there. Thank you so much, Chris. So again, this is an overview. If you've got any specific questions or you want specific advice, then do obviously get in touch with us, and we can help and support you. But really, what can employers do now? So what practical steps can employers take to kind of mitigate the impact of this?
So first and foremost, really good data and knowledge of your workforce.
Absolutely, audit.
Underpins everything.
Yeah.
So regardless of whether you have a workforce of 5 individuals or 500 individuals,
Yeah.
really knowing what the visa routes and immigration status of your workforce is critical. See, it feels like Brexit all over again with this. That workforce data is massively important in this. So knowing where you are potentially liable, where you might have someone, and that's not saying that you need to know everyone who you're sponsoring. It's everyone who's on a visa. So if someone is, say for example, on a dependent visa, they may well be coming to you over the next 12, 18 months saying, could you sponsor me because my partner is no longer sponsored? And that might be something that you would want to do. And it happens very, very frequently. We do it with a number of clients already on the call, where someone who's working for you already on a dependent visa and you want to offer them sponsorship. So having those proactive conversations as early as possible is really important. Where you identify them, getting the application submitted before spring. We do have time. We've got best part of 4.5 months until submission, so there is plenty of time to do this. You certainly don't need to be panicking and getting this done before Christmas. This is a nice little January project. when things
have it on your radar.
Yeah.
But certainly the data point, know your people, know your teams, kind of a universal
absolutely.
message, really.
So first and foremost, know your teams, know your data on your workforce in terms of their immigration status. Second of all, start discussing with your finance directors and your finance team what the budget looks like, certainly for this year, because this is all going to land in this year's budgets, depending on where your financial years are. So start preempting and start forewarning your FD and your finance teams that there might be some additional costs where you're bringing costs forward from future years, but you're going to be putting them into this year. So forewarn your finance directors, forewarn your finance teams that there is probably going to be increased costs over the next few months. And then finally, sales plug, sign up to our newsletters, get in touch with us, because what we do with when there's changes announced and when there's any updates that come out, we send our analysis out. So I'm always watching and writing the analysis live as they're published. So we get our analysis out within a matter of hours of announcements made. So if you're on our mailing lists, if you're on our distribution list, we can get the information to you really, really quickly. And then if there is a potential scenario where you need assistance with, we can then jump onto it really quickly now.
Absolutely. And I suppose, another point is going to be around retaining staff.
Yeah. Isn't
it? And I think, that's another takeaway from this is going to be, how can we keep and retain the staff that we have? and keep them engaged and motivated and part of your employer brand and culture, so that hopefully you're not stuck in a situation where you've got people leaving you and then you're having to sort of, dip your toe back into the system in, the summer, when you're going to be caught by these new rules. So I think there is, in all of these situations where there are challenges, and of course there are huge challenges, but also opportunities to be able to look at how you can work more positively with your workforce, to avoid the kind of the peaks and troughs in recruitment. But certainly, there are some huge challenges there for businesses, particularly, the leisure and hospitality sector, as we know, is already in a very challenging environment. So, if we can help, can't stress enough, do get in touch. And I'll be sending out details of how you can sign up to our mailing list, or, or link in with us as well, because we do post and share a lot of information on this. So thank you, Chris. Again, fantastic overview.
One final question, just to answer before I pass on to you. So Jenny, thank you for your question, Jenny. So the question is, when do we expect we will have more certainty about whether the new salary will apply to applicants if it's due to come into effect in spring? That's the $1 million question at the moment. The honest answer is we don't know. If I'm being honest, Jenny, the Home Office are very guarded with these sorts of things. We've already seen the Home Office backtrack on the salary threshold for family members over the last week, where initially they said that it was going to apply extension application as well as new entrant, which was a horrific thing that they would have done if that were coming. So I honestly think that the Home Office don't even know the detail, if I'm being honest at the moment. My understanding from people that I've spoken to is that the Home Secretary's announcement caught the policy areas of the Home Office off guard. They knew there was a change coming, but not to this level of degree, and they were not set up in terms of their capacity to deal with all the legislative work that has to go on around preparing a statement of changes, to react to that as quick as they normally do with changes. So there has been situations where the detail has been announced 2 weeks before the changes in the past, and you've got people like me screaming at the Home Office to send details out because there are so many things hinging on it. I would like to think, Jenny, that they will get the detail out in January or February. Don't be surprised if we're still sat in March waiting for the statement of changes. I know that's a really dour point to end on, but it's you need to be prepared realistically.
It is realistic.
Yeah.
Obviously, with where we are at. So very quickly, again, we will sort of jump off of one roller coaster onto the other roller coaster that is employment law. We've got lots of laws that have been passed this week. The carers regulations, they were passed. Carers Act was passed this week. Protection from redundancy regulations were passed this week, as well as an announcement that the government is proposing to bring in flexible working as a day one right from April 2024. So there is lots and lots going on, and as you know, we'll be running separate sessions on that. I just wanted to, well, I was going to say quite lightheartedly, but I don't think anything that sort of refers to the working time regulations and holiday pay as being lighthearted, unfortunately. But not to sort of mention the B word again, but I will do, obviously with the sort of the Brexit legislation, sort of coming to an end. We've got the end of that sort of first transition period at the end of this year, and it was very much a use it or lose it type response. So what we have seen is that from January, again, subject to parliamentary regulation and parliamentary scrutiny, that to ensure that workers' protections continue to be enshrined within UK law, particularly focusing on the EU case law. So this is very much stuff that we are already doing anyway, because we're doing it because of EU law, but making sure that case law is enshrined. So we're going to be seeing some changes to GP, which I mentioned in the last webinar. Also some changes to the Equality Act as well. And again, spoke about that sort of last time, but again, you know, focusing on that for 2024. Just on the holiday point, again, not related to it, but again, those of you that have heard me speak before about holiday, please make sure that your staff have taken their holiday, employees and workers. You know, we don't want employees storing up lots and lots of leave. We don't want employees carrying over lots and lots of leave. We want them to be taking it, you know, throughout the holiday year, remembering, of course, that holiday is a health and safety requirement as well. We're going to be seeing some changes about recording of working time, so hours worked, but again, from experience, it's always worth keeping records of the work that your people do, and certainly employers will be required to maintain adequate records of hours worked, and certainly there will be some responses there that HMRC will need as well. We're going to see some changes as well after the sort of Harper Trust and Brazil case, which left many of us scratching our heads as to why somebody who works part year is entitled to more holiday than somebody who works part-time. Always an odd one to sit with me. So again, look out for some changes there, which is going to allow employers to be able to go back to basically what pre-Brazil was, looking at that 12.07% of holiday pay that you're going to be able to pay employees and workers who work part year as well as irregular hours. Also with holiday pay, again, making sure that we are using the reference period. So it's not just basic salary. If you've got employees and workers who have that irregular earnings, so they're earning bonuses or commissions in the reference period, so whether that's 12 weeks before or 52 weeks in the case of irregular workers. So making sure that holiday pay accurately reflects the actual earnings of individuals rather than basic salary. So again, that's going to be set now in legislation. And thankfully, we will have some guidance as to what is actually normal remuneration. So again, that's going to be helpful for employers. We're going to retain the distinction between 4 weeks basic EU holiday and then the 1.6, the additional leave, 4 weeks paid at full pay, normal remuneration. The 1.6 can be paid at base pay, but most employers that I know will just simply use the total holiday entitlement. They won't split it down. But what I would advise you, and something I do in my contracts when I'm drafting them, is to make sure that you've got that distinction between basic EU pay and the additional pay and any contractual pay, just in terms of what holiday individuals use first. So again, December, January is always a fantastic time to review your practices. As Chris said, know your people, know the data, check your holiday as well. But again, making sure that you're looking at your contracts, you're looking at your policies as well, particularly as we move forward into January and beyond with some of the changes that we've got coming up. So holiday, as I said, is always a tricky one, but I think, hopefully we will have some clarity next year, particularly around those individuals that are on a part year or irregular pay. And I think that ability to roll up holiday pay to pay the 12.07%, again, with a roll up, making sure it's clear on the face of the pay statement that you've got your pay plus obviously the sum for holidays. I think that's going to be a real plus for employers. So as ever, watch this space. Do get in touch. I'll just pop up our contact details there on the screen if you want to get in touch. But as I said, I will be writing to everybody as well. So lots going on as ever on our dual roller coaster that is immigration and employment law. So thank you, Chris, for that.
Thank you.
As ever, lots of detail there, and again, super helpful to our audience. So thank you very much to everyone who's joined us this year for our webinars, our training courses and our training events that we've run in-house. And look very much forward to seeing everybody next year in person, hopefully, but certainly on the webinars as well. And that really leaves me to say, have a wonderful Christmas and a very, very peaceful and prosperous new year. And thank you very much for joining me. And thank you, Chris.
Thank you, everyone. Thanks.
Thank you very much. See you soon.